cases, he suggested that it may be desirable that local authorities should not be obliged to inform the Council. But the chairman remarked that if the Commission went into the question whether cases of espionage should be made an exception to the whole principle of consular protection and communication with nationals, would have to be reopened. The extracts suggest that the problem of espionage was very much on the table, and yet no exception was made to such allegations in the language to Article 36. Pakistan brings up the issue of problems confronted in implementing the provisions of the Vienna Convention in the context of pleas for asylum and in situations of dual nationality. Both these also establish that the Vienna Convention is indeed the exhaustive rubric of consular access. It is invariably the provisions of the Vienna Convention that provide the basis for resolving situations, finding solutions consistent with the Convention. One of the matters brought up by Pakistan is an application of Article 36 to a person of dual nationality, which presents legal challenges, no doubt, with us sua generis, but they need not be explored in this case. Pakistan gives a series of examples which in its assertion are historic and modern examples of espionage that states often operated on the footing that they were not entitled to or were not going to be able to gain access to their espionage agents when they had been captured. India submits that the material relied upon for what happened in those cases is hardly reliable, for it is wanting in relevant detail. The plain language of a treaty, if it is contrary to the conduct of states, cannot be whittled down by reference to state practice. A treaty, in fact, is set about at times to bring about uniformity in state practice. So even assuming that the conduct of states evincing a consistent conduct, which is sufficiently clear, documented so as to satisfy the rigorous standards of what constitutes state practice, it cannot alter the plain language of a treaty. The random examples given by Pakistan in any case do not assist the court in coming to any such conclusion of state practice. On the contrary, recent instances of arrest by China and Russia, facts in public domain, of persons on allegations of espionage based on information in public domain show that the conduct of the receiving state was compliant with Article 36. These the court would find in the judges' folders at tab 1 and 2. Pakistan in this misadventure does not push it to the point of suggesting that there is an established practice to show that consular access is invariably denied in such cases. Individual incidents can then at best establish that Pakistan may not be the only state which has violated Article 36 of the Vienna Convention or similar provisions in bilateral treaties that preceded the Vienna Convention. There is no material place that would establish that giving consular access prior to extracting a confession would have so imperiled its national security or so hampered the investigation that consular access was denied. There is no explanation for giving consular access after that also. I now move, sir, to a discrete issue, the 2008 bilateral agreement. In no official communique to the Government of India has Pakistan ever suggested that consular access to Jadhav was circumscribed by the 2008 agreement. Apart from a reference in a press briefing by a spokesperson of Pakistan government on 20th April 2017, the bilateral agreement of 2008 was never referred to, and rightly so. The question of consular access provided for under Article 36 is being circumscribed on account of provisions of a bilateral treaty does not arise. Article 36 is the provision of a multilateral treaty, and bilateral treaties covering the same subject matter can be accommodated as long as, and I quote, they are treaties confirming or supplementing or extending or amplifying the provisions of the Vienna Convention. This is the clear language of Article 73 of the Vienna Convention. The 2008 agreement was entered into, and I quote, for furthering the objective of humane treatment of nationals of either country arrested, detained, or imprisoned in the other country, and by which the two signatory states, India and Pakistan, agreed to certain measures. These included the release and repatriation of persons within 1 month of confirmation of their national status and the completion of their sentences. The agreement recognized that in the case of arrest, detention, or sentence made on political or security grounds, each side may examine the case on its own merits, and that in special cases which call for or require compassionate or humanitarian considerations, each side may exercise discretion, subject to its laws and regulations, to allow early release and repatriation of persons. India does not seek any early release or repatriation of Jadhav as contemplated by the 2008 agreement. The existence of a bilateral agreement and some of the relevant to the assertion of rights to consular access under the Article 36 of the Vienna Convention. This is also consistent with Article 41 of the VCLT, which recognizes the principle that two or more parties could modify the terms of the treaty as long as the treaty permits such modification, or at least does not prohibit such modification, and that any such modification cannot relate to a provision, the derogation of which is incompatible with the effective execution of the object and purpose of the treaty as a whole. The Vienna Convention creates specific rights in favor of those states and in favor of nationals of sending states in relation to consular access, creates corresponding obligations upon receiving states that they arrest, detain, or try, and sentence nationals of other member states in a particular way. Bilateral treaties which create obligations can only supplement the provisions of the Vienna Convention. Bilateral treaties cannot modify these rights and the corresponding obligations which form the object and purpose of Article 36. There is nothing in the language of the 2008 treaty which would suggest that India or Pakistan ever intended to derogate from Article 36 of the Vienna Convention. But even if there were such language, it would yield to the provisions of the Vienna Convention. Considering that India and Pakistan are neighbors both on land and sea, where people who live in the border areas frequently stray into the other country and end up in custody, it was found necessary to have a bilateral agreement that could supplement the Vienna Convention. Thus, the matters covered in subparagraphs 1, 3, 4, and 5 were agreed to, and these are not matters covered by the Vienna Convention. They supplement and extend the provisions of the Vienna Convention. Pakistan appears to rely on paragraphs 4 and 6. Neither of them suggest that they detract from the general provisions and the overarching protection of Article 36. The requirement that each government shall provide consular access within 3 months does not give an excuse to delay consular access. But even if it does apply as supplementing or amplifying, at the best, it only fixes an outer limit of 3 months in which consular access must be provided. Not necessary to decide the issue. Consular access has never been provided. Even if paragraph small Roman 4 of the 2008 agreement was to apply, Pakistan should have provided a substantial explanation for why it needed 3 months for providing consular access, and upon which it could have claimed that it has complied with treaty obligations. Even on the erroneous premise that paragraph 4 applies, Pakistan has not complied with the treaty obligation. But worse is the case of reliance on paragraph 6 of the bilateral agreement. The phrase "examine the case on its merits" makes apparent that it applies to the agreement to release and repatriate persons within 1 month of the confirmation of their national status and completion of the sentences. As an exception to this, India and Pakistan reserve the rights to examine on merits the release and repatriation of persons upon completion of their sentence, where their arrest, detention, or sentence was made on political or security grounds. Paragraph 6 of the 2008 agreement also calls for compassionate humanitarian considerations, in which each side may exercise its discretion to allow early release and repatriation of persons. The focus of 2008 bilateral agreement in these paragraphs was upon the return of those arrested, tried, and convicted in the receiving state, being nationals of the other state. As I said, India and Pakistan have shared land and sea borders, and there are frequent occasions when nomads or fishermen stray across borders and are arrested. These agreements primarily sought to arrest problems arising out of these kind of situations. Judge Shigeru Oda's treatise relied upon by Pakistan deals with the contrast between what is now Article 30 of the VCLT and the Vienna Convention. Article 73.2 of the Vienna Convention is cited as a provision which recognizes the right to supplement its provision by bilateral treaties, and I quote, which do not derogate from the obligations of the General Convention, unquote. The text of Article 30, Subarticle 2 of the VCLT, according to the author of the treaties, goes far beyond mere confirmation of the legitimacy of bilateral agreement, and he argues that if 30 Subarticle 2 were applied to the bilateral consular agreements, they would prevail over the Vienna Convention. This analysis of Article 73 is directly contrary to what Pakistan invites this court to hold in the present case. Clearly, it is Article 73.2, which is a part of the Vienna Convention, that would apply, and not the general provisions of Article 30. India is not a party to the VCLT, while India accepts that a number of the principles incorporated in the VCLT are codification of the general principles of international law, and for that reason of relevance, a suggestion that Article 30 of the VCLT would override Article 73.2 of the Vienna Convention has only to be stated to be rejected. Pakistan states the point, I must confess, with a degree of ambivalence. It doesn't seem to gather the courage to suggest that Article 30 of the VCLT would override 73.2 of Vienna Convention. Instead, Pakistan claims that a bilateral agreement is a, and I quote two words they use, supplement and or amplification of Article 36. India generally agrees with this assertion, but points out that the premise is destructive of Pakistan's case on the interpretation it seeks to place on para 6 of the bilateral treaty. Article 6 cannot destroy Article 36. Paragraph 6 cannot destroy Article 36. The point is as simple as that. The phrases political and national security in paragraph 6 are amorphous and indefinite in their import. If both countries can unilaterally decide upon and police the application of Article 36 to individual cases, Article 36 would have lost its meaning. Arrests on trumped-up charges are frequently made by Pakistan. The present case is a textbook case of such conduct. All that Pakistan would then have to do to wriggle out of Article 36 is to add a ground that can provide a hook to later claim that political considerations, quote unquote, in the arrest, even if it does not show up in the final charges and conviction, was the basis for denying consular access. Pakistan may then well denounce Article 36 itself. Having finished my submission, sir, therefore, on the construction of Article 36 and the irrelevance of the 2008 bilateral agreement, I move now to an important point. Article 36 is a facet of due process. The obligations of states towards aliens features as a recurrent theme of international law in the evolution of the jurisprudence of international law. In Barcelona Traction Light and Power Company, this court expostulated the principle that created obligations erga omnes upon the states. The court held that such obligations derive, for example, in contemporary international law, from outlawing acts of aggression and genocide, as also from the principles and rules concerning the basic rights of the human person, including protection from slavery and racial discrimination. Some of the corresponding rights of protection have entered into the body of general law, and the example of the Convention on Prevention and Punishment of Genocide is referred to. Others are conferred by international instruments of a universal or a quasi-universal character. These words would perfectly apply to the Vienna Convention. The protection of human rights generally, and specifically in the context of aliens, has been a significant strand in the evolving jurisprudence of international law. The Universal Declaration of Human Rights, proclaimed and adopted in 1948, in the words of the Secretary General Ban Ki-moon, is, and I quote, become a yardstick by which we measure right and wrong. It provides a foundation for a just and decent future for all, and has given people everywhere a powerful tool in the fight against oppression, impunity, and affronts to human dignity. The principles incorporated, which recognize the universality of human rights, reflect contemporary understanding of what constitutes due process. The principles of recognition of human rights have also evolved into principles of international law binding on all states erga omnes. The observations of this court in Tehran case bear repetition. Wrongfully to deprive human beings of their freedom and to subject them to physical constraint in conditions of hardship is manifestly incompatible with the principles of the Charter of the United Nations, as well as with the fundamental principles enunciated in the Universal Declaration of Human Rights. Powerful words. This general principle would apply not merely to members of the diplomatic corps, but to all human beings, and in present context, to nationals of sending states. The International Covenant on Civil and Political Rights, which came into force on 23rd March 1976 in the preamble, states, the recognition of the inherent dignity and of the equal and unalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. Recognizing that these rights derive from the inherent dignity of the human person. It goes on to state that considering the obligations of states under the Charter of the United Nations to promote universal respect for an observance of human rights and freedoms, the parties agree upon the articles. Article 14 sets out what is recognized as the rights of a person in relation to determination of criminal charges. Honorable President and honorable members of the court, I strongly submit that the Vienna Convention is a powerful tool that ensures at the multilateral level, almost at a universal level, the facility of consular access to foreign nationals who have been put on trial in a foreign country. This is based on the recognition of the rights of a national of the sending state to put up a fair defense at the determination of criminal charges in the host state. And this becomes meaningful when he has the benefit of consular access in its various dimensions recognized in Article 36. One of the vital areas of human rights is the treatment of those accused of crimes. The principles of due process, expressly recognized in the ICCPR, must jurisprudentially be considered to be a universal obligation binding upon all states erga omnes. Consular access to a national of a sending state charged with a crime in a sending state evolved as a practice and found codification in Article 36 at a time when human rights jurisprudence was in its incunabulum. It was recognized by those who wrote the treaty to be a right without exceptions. They went further and wrote the right not just in favor of the sending state and its consulate, but also in favor of the nationals of the sending state. With the universal acceptance of the right to a fair and an impartial trial, and the right to defend oneself against criminal charges, including the right to engage a lawyer of one's choice in a foreign country, as a rudimentary rule of due process, Article 36 becomes a vital cog in the wheels of justice. As was said of the Geneva Convention by this court, so can it be said about the Vienna Convention, that in some respects the principles enshrined were a development, and in other respects no more than an expression of the fundamental principles of humanitarian law and diplomacy. These measures were designed to put in place an instrument essential for the effective cooperation in the international community and for enabling states, irrespective of their different constitutional and social systems, to achieve mutual understandings to resolve their differences by peaceful means. In a judgment delivered in 2010 in the Diallo case, this court considered a challenge to the actions of the Democratic Republic of Congo in respect of detention and expulsion of the national of the Republic of Guinea in the backdrop of rights and the obligations under the ICCPR and the African Charter. This court also considered allegations of the violation of Article 36, paragraph 1b of the Vienna Convention. In the context of Article 36, this court held that the provisions, as is clear from their very wording, are applicable to any deprivation of liberty of whatever kind, even outside the context of pursuing perpetrators of criminal offences. Unquote. This is consistent with the absolute nature of the obligation, as also a fundamental principle of due process, that the greater the severity of a charge, the greater the need for punctilious compliance with procedural safeguards. And this is recognized as the elements of due process. This court in Diallo's case went on to say, and I quote, "It is true, as the DRC has pointed out, that Article 13 of the Covenant provides for an exception to the right of an alien to submit his reasons where compelling reasons of national security, quote unquote, require otherwise." The respondent maintains that this was precisely the case here. However, he has not provided the court with any tangible information that might establish the existence of such, quote, compelling reasons, unquote. In principle, it is doubtless for the national authorities to consider reasons of public order that may justify the adoption of one police measure or the other. But when this involves setting aside an important procedural guarantee provided for by an international treaty, it cannot simply be left in the hands of the state in question to determine the circumstances which exceptionally allow that guarantee to be set aside. The expulsion of a foreign national of a foreign state has serious consequences on his rights. But the trial of a national of a foreign state, and that too for serious consequences that result in the award of the capital punishment, have far greater consequences on the rights of the person. In the context of expulsion, the ICCPR recognized an express exception. Yet this court held that the state cannot self-certify compelling reasons of national security. The approach that the seriousness of the allegations justify the violation of procedural safeguards by which an accused can secure fair trial betrays a fundamental failure to understand the very basics of due process principles. Even where in relation to Article 13 of the ICCPR and Article 12 of the African Charter, both of which deal with expulsion of a national of another state, compliance with international law is to some extent dependent here on compliance with internal law, and this court read two safeguards. It held first that the applicable domestic law must itself be compatible with other requirements of the Covenant of the African Charter, and secondly, an expulsion must not be arbitrary in nature, since protection against arbitrary treatment lies at the heart of the rights guaranteed by the international norms protecting human rights, in particular those set out in the two treaties applicable in this case. The overlay of human rights was sharply brought out. This court cited the jurisprudence of the Human Rights Committee established by the ICCPR and the interpretation of the European Court of Human Rights and the Inter-American Court of Human Rights. This is a recognition of the degree of cross-fertilization of jurisprudence and a testimony to the growing fabric of the law that has drawn strands from these diverse treaties, from the decisions of fora which administer those treaties, and from the basic principles of human rights jurisprudence. One very important strand of this fabric is the Universal Declaration of Human Rights. Its nomenclature itself establishes that it should be considered a principle erga omnes. The inalienable rights recognized in 5, 9, and 10 are non-derogable. Article 5 provides nobody shall be subjected to torture or cruel, inhuman, or degrading treatment or punishment. Article 9 provides that no one shall be subjected to arbitrary arrest, detention, or exile. And Article 10 provides that everyone is entitled in full equality to a fair and public hearing by an independent and impartial tribunal in determination of his rights and obligations of any criminal charge against him. The body of principles for the protection of all persons under any form of detention or imprisonment adopted by the General Assembly's Resolution 43 of 173 of 9th December, recognizes consular access in paragraph 16. Paragraph 2 of Principle 16 provides that if a detained or imprisoned person is a foreigner, he shall also be promptly informed of his right to communicate by appropriate means with a consular post or the diplomatic mission of the state of which he is a national, of which he is otherwise entitled to receive such communication. Please mark the words, in accordance with international law. It considers consular access communication to be in accordance with international law. I submit this resolution establishes that by 1988, Article 36 was assumed to have the stature of a principle of international law. The 1985 Declaration of the Human Rights of Individuals who are not nationals of the countries in which they live recognizes that Article 10, that an alien shall be free to communicate at any time, to communicate with a consulate or diplomatic mission of the state of which he or she is a national. Article 36 has been interpreted and applied by the Inter-American Court of Human Rights.
Mr. Salve, before you turn to the next aspect of your argument.
Sorry, sir?
Before you turn to the next aspect of your presentation.
Yes.
The time might have come for you to have some rest, first of all, because you deserve it, and for the court to observe a 10-minute coffee break.
Thank you, sir.
Okay, so the sitting is adjourned.